It takes an Argentine to come all the way to build the bridge. She spent a semester in Argentina, which I guess is why I'm here now. And apparently some of you who are 2Ls now and editors for the law review here also spent a semester in Argentina, right? So for me, today is a memorable day because when I was 17 years old, I was an exchange student in New Orleans when I was in my senior year of high school. And although presently my teaching connections / associations with Louisiana schools are with LSU and Tulane, and Loyola, excuse me. Back then, when I was very young and I came here as a high school student, Tulane was the only school I was familiar with. And the family with whom I stayed lived on Fontainebleau Drive down the road, exactly in this direction, you don't need to go left or right, you hit it. So I would come and play in the Tulane grounds. I didn't jog in those days because I was smarter, so I would play soccer and do funnier things that you sometimes can't do when you become older. At least you get injured. And with my other 15 Argentine students, we organized a game against the US kids, most of whom were Tulane students, I suppose undergrads, I don't know, young. It was the first time I played a mixed soccer game. We didn't and don't have that in Argentina, which is why we win the World Cups, just kidding. And that time I got brutally injured on the Tulane ground by a girl who stepped on my ankle, broke it completely. So when the tour proceeded to the places like Aspen and Vail Valley in Colorado, where I also went to high school for a bit, I was the one who couldn't ski. Anyways, I still have very fond memories of that time, of my first connection with the school, which is why I'm so happy to be here today for the first time. The article I'm going to talk about, in a way very different from the way you find it in the article, if it survives Melanie's and her colleagues' hands, was co-authored. I wrote it with one of my LSU students. This was the 4th time I wrote with a student out of roughly around 20 times I wrote an article in English. Most of what I write in Spanish. That's like a story for another day. How do you manage to do those things and jog? Andrew Shenevert, he would have loved to be here today. He's in Houston working for Holland & Knight, will be Katya's colleague from August, I guess. She has already met him there during the summer associate kind of thing, but believe me if I tell you that the reason we got the offer was completely independent of whatever friendship they made at the law firm. I will speak for both of us today, although much of what I'll say is really my own thinking, especially if you find anything particularly brilliant or crazy, that's me. So, what's the reason we offered a theory of overruling to the conservative so-called majority in the Supreme Court? The title of the article, do you remember it, Melanie, by any chance? You need to swallow first.
Maybe so. I don't have a whole title committed to memory yet, but I'll go home and memorize it immediately after this.
You didn't have to answer. It's called a modified approach of overruling for the conservative majority. The reason for us to, I'll say alternatively for us, for me, to offer this alternative approach is that we think that the Supreme Court always has had a deficient approach to overruling. And when I say always, I'm telling you from now onwards that our point of view is not a partisan one or an ideological one. If it works and can work in any direction, right, left, conservative, liberal. I am worried, I've been worried for many years about a certain lack of honesty in the Supreme Court when it comes to overturning precedent, where the single most important reason for overturning precedent is being played down or silenced or omitted or more commonly denied. And that reason is that the overruled precedent was wrong. It's like the thing to say, we're not doing this because that was wrong. Well, I guess we want to say something that is more or less the opposite. And that is that for you to start to consider whether overruling is the sound course of action, first you need to ascertain and prove, insofar as proof goes in the law, that the precedent you're going to get rid of was wrong. This presupposes an ability often denied in bars or by those who edit this anarchist journal called Anti-Gravity that Adrian, my student back there, and I love. They deny, by and large, the possibility that someone can actually know the truth about something other than 2 + 2 is 4, or this wall, it is there. Other than that, they'll deny, and most people in bars and in conversations will deny. They'll say, well, that is your point of view. Now let me tell you my point of view. Philosophy, as you know, and I'm simplifying a lot, calls this relativism, where each person has a point of view and truth is relative to each agent, as the editor of this magazine says in the editorial for the January issue. Instead, if you affirm that the Supreme Court is able to identify a mistake such that you can say that, for example, Roe versus Wade was wrongly decided, then you're affirming the ability to speak the truth in matters that go farther than 2 + 2 is 4, or this wall is here. In other words, truth in humane affairs, including the law. Similarly, when in denial a plurality of the Supreme Court in Casey in 1992, when they in denial affirmed that the core of Roe versus Wade was right, they were producing the same kind of optimistic judgment about the truth. This is why I told you that it can go both ways. You can be a believer in objectivity, like Ronald Dworkin was, even if you are, like he was, a completely pro-choice person, or the other way around. This is our starting point in our argument for overruling, and we think that, as I said earlier, everything the court has given us until now hides this. Of course, it's very convenient to hide this, to suppress it, to underplay it, because if I stop talking here and we bring some out of bounds alcohol into the room and we start to talk relativism, anti-gravity, and abortion, we probably would get into a fight, which is why Katya knows that you don't talk politics in the United States or other similar things, but when you go to Argentina, it's the only thing you talk about. Controversial issues, etc., over lunches, meals, dinners. This is a very controversial issue, a very controversial statement. You are affirming that Supreme Court justices are human beings, that human beings have the ability to know, that that ability is limited, is open to failure, but that intelligent people may get it right if they're honest. These are very many assumptions and presuppositions. They are so shocking that, Melanie, we had to play them down and put them in the footnotes of our article to some extent, so that perhaps you wouldn't notice them too much and run to Mary Ryan saying, alert here. Well, we aren't the first to affirm this, of course. I mean, Plato affirmed this, Aristotle affirmed this, versus the sophists, versus the challengers that would say, what's the name of this doctrine? Man the measure. Man is the measure of all things. If you did undergraduate studies in philosophy, you will be familiar with this. There are no truths in moral matters. Whatever you say is true. Man the measure. Protagoras, one of the sophists. Right, so this isn't really new. That was there in that conversation, and it's today there in the conversation with relativist multicultural theories of law that prevail by and large, where you think that, you think that, you think that, now let's add, let's count, who has more numbers, that's the truth. So I guess that's what's at the heart of our article, and I think that's a lot. We also consider that if a majority of the Supreme Court is able to argue that a certain precedent is wrong, to overrule it, or is right to keep it, we also argue that this isn't enough. As in life, sometimes, even when you identify a forthcoming state of affairs as undesirable and wrong in your life, sometimes you will still choose to live with it. You will make a calculus, an estimation of what the consequence will be of stopping this bad thing from happening, and sometimes they will be so negative that you will decide to keep that mistaken precedent, or in your lives, to let that thing, let's call this thing your boyfriend, your girlfriend, just kidding, stay in your life, because there are more benefits than shortcomings in not dumping this spouse. Again, just kidding. Not really. My students know that whenever I say just kidding, you keep what came before and get rid of the just kidding. And I think that's true for all of you. Yes, so it is still, I think, very different for a Supreme Court on a majority to do what I just said, to realize that a past decision is wrong and keep it because of the consequences of overturning it. This is very different from not passing judgment about whether it's right or wrong, which is what they try to do all the time on both sides to avoid conflict. So I think there is a great difference there, even when sometimes them and us would reach the same result. For example, not to overrule. Now, I'm wrapping up so that we open it into a conversation, and maybe I'll go and grab a drink for me too. Let me just pose the familiar scenario where there is a new justice in the Supreme Court, or maybe two, or maybe three. This happened when Casey was decided. There were 3 new justices. This happened when Dobbs was decided. There were 3 new justices. And if you want to make it juicier, if President Biden would win the election, assuming he's the candidate, and assuming that one of the more senior justices dies, or that one of the Republican nominated justices resigns force majeure, it could happen again in the opposite ideological direction. And the question will be always, in Casey, in Dobbs, and in 3 years, with Biden as a president who now packed the court the way Trump did, packed, so to speak. What can we legitimately expect from a new Supreme Court justice when it comes to overturning precedent? For example, are we entitled to expect that a new liberal majority of the Supreme Court, in my Biden death resignation scenario, should uphold Dobbs because stare decisis? Are not those guys in 2026 entitled to evaluate the correctness of Dobbs in a way similar to which the conservative majority did in denial regarding Roe versus Wade? And my answer is yes, they are. They are entitled to overrule Dobbs in 2026 if they argue successfully that Dobbs is wrong. Now, the raw power question will be always one and the same. The numbers. Who has the numbers to overrule? But we go back to my initial optimism about knowing the truth that will allow us here in this room in 2026 to distinguish 2 hypothetical majorities in the liberal Supreme Court. One that poorly argues and unsuccessfully, in our opinion, that Dobbs was wrongly decided and overrules it. So this seems to offer reasons to prove that that was a mistaken precedent. We are optimistic that we can distinguish that from another majority that is actually appealing and convincing in the reasons they offer about that alleged mistake of law. The end result, the raw power result, will be the same. Whoever has 5 votes will be able to decide if they overrule or not. But what I'm saying is, from an evaluative point of view, the reader or a dissenter can distinguish what is only a raw exercise of power from a reasoned one, even if perhaps you will not agree with the reasons given. And finally, let me introduce briefly, and if you are interested, you can go to the article in order to get more on this, for which they'll have to wait for 3 years. No,
3 years? Yeah,
just
4 maybe.
I think you start to understand my methodology. I think we'll get along well with the process. I hope your colleague too will be as a joker as I am. So there's more on this in the article. What I've said so far applies to those matters that we could call, think again of the scenario of the new Supreme Court Justice so that I can illustrate what I want to say better. Think of the hearings in the Senate, think of Amy Coney Barrett or Dana Douglas in 2026. Everyone who supports her, Amy or Dana, is expecting she will do the right thing about abortion. For example, abortion is only an example. You shouldn't tie their hands, Barrett's or Douglas's. But this is only true of a very limited number of cases where people take these things to their hearts. They're so important that they make part of the single most important class in law school, which is, as every professor says, the one I teach, constitutional law. But when you're talking about patent law, for example, and you have a precedent that with the same gnoseological ability, epistemological ability, you discern that has been wrongly decided, there, come on, no one is expecting you, Dana Douglas in 2026 or Amy Coney Barrett 3 years ago, to overturn it because you think that's wrong. This is all in the wisdom of Justice Brandeis in the 1932 Barnett case, where he distinguishes the weight of horizontal precedent, of horizontal stare decisis in constitutional matters, lighter weight, more room for maneuver and for overturning. The famous phrase by him back then, stare decisis is not an inexorable command. It is in general the sound principle, but it's not the last word. When it comes to patent law and to many technical aspects of our Constitution, it is almost the last word and almost an inexorable command. Thank you.
So I think that I find this topic really interesting because I think the thing that I found very frustrating when taking con law was the idea that clearly they were just disagreeing with the previous case, but twisting themselves into knots to pretend like it was all still in a long line of cases that hadn't changed. But I wonder though if having really charged issues like abortion have not have to follow stare decisis as much could lead to just supercharging like the politicization of the Supreme Court, which is already very political, but could maybe lead to presidents adding new members to the court or things like that to try and get the numbers in and exercise that raw power you're talking about. And maybe that raw power would yield like very thought out and well-reasoned cases, but would that lead to less like trust in the institution? Do you think that would be likely to happen? If it did happen, would it be a problem?
Thank you, Mary. I guess there are several compatible and different answers to your question, some of which may sound funny. One could be, can the trust get worse than it is now? Another one can be, hasn't President Biden already tried to pack the court? Hasn't he created a commission to try to get moral and political support to water down the conservative membership of the court and failed subsequently. Didn't President Roosevelt try to do the same? You see how this goes across the ideological world, although I guess in these cases it will be more the left that has been interested in diluting conservative standards in the court by packing it. But in Argentina, it has been exactly the other way around. It's been the conservatives who successfully moved the size of our court from 5 to 9, in order to water down liberal ideology. So it goes both ways. I think that anything that adds honesty and sincerity is very unlikely to happen, but would be very welcome. Yes, thank you.
Hi again, I'm Tate. Met you upstairs.
Yeah. You're
I'm
one of the ones who's going to have mercy.
Yes, that's right. One of the previous Buenos Aires students. I'm curious about, in perhaps your more global expertise that a lot of us as law students do not have, or haven't been able to learn. Are there legal systems that take relativism into account more so than perhaps the US system, which seems, as you spoke about kind of at the beginning when you were speaking about finding the truth?
Thank you, that's a great question. So my tentative answer, I will owe you a better answer for next time we meet. But my tentative answer is yes, there are. And these are systems where there is less of a judicial review of legislation and more of a political control of legislation, where there is no pretense that what we're doing is the law when we overrule. What we're doing is starting afresh, because now there is a new majority. So in generally all centralized systems of review that deny courts, including the Supreme Court, the ability to strike down legislation, they are farther removed from that and closer to what I was talking about. And that's the case of the US and of Argentina. But when you don't give the courts that ability and you concentrate it in a political body called the Constitutional Tribunal, that is made of politicians, then it is very clear that this is about what Mary doesn't seem to want. By the way, what you just told us reminded me of the following. Even in those countries that allow, you could say, more room for relativism or for politics in deciding such issues, even there are lawyers and there are courts. And cases in those courts that discuss civil law matters, commercial law matters, criminal matters in Germany, operate in the same way they do in the United States. And this way, I think this is usually neglected or overlooked as well. This way also presupposes the idea of the truth, because that's what a trial is about, and that's what an exchange between two lawyers that have conflicting claims and clients go about. At least it's possible to try to do it that way. So I guess if our theory of overruling is correct, it doesn't apply to overruling only, but to any statement about what is the law on a certain matter. You're saying this is true. You will always say, I think this is true, of course, but that doesn't make it a relativistic statement, as it also doesn't for me to say, I think this wall is here. We all know what that means. Philosophers use the idea of transparency to say that these are transparent statements. This wall is here. I think this wall is here. And the same is true with statements of law.
I think people know I can always ask questions until the end of it. So
How
if,
much
if,
do they-
if anyone else has questions,
How
cut me
much do
off.
they pay you, Mary?
Not enough. But earlier you cited Brandeis as someone who had, endorsed the idea that constitutional matters should have less stare decisis. Do you think there are any current justices that go along with that line of thinking, or any that, even if they haven't explicitly said so, and if any of their decisions have sort of hinted that they're open to that possibility?
Every single justice in the Supreme Court for the last 50 years has shared Justice Brandeis' view. I find it very surprising. I was just stating the law, but I wasn't saying I don't find it surprising, and I wasn't saying that I fully endorse it. In Argentina, it's exactly the other way around. When we're talking about constitutional matters is when our version of stare decisis is at the highest. But every justice, all the justices in Casey, the main problem for the plurality was Justice Brandeis. Everyone agreed that Justice Brandeis was right, but if he was right, everything the plurality says is wrong. Because what he's saying is, you can do whatever you see fit. If Roe is wrong, go ahead and overrule it. So they quarrel with Burnett versus Coronado Oil, the 1932 precedent, and they come with a theory, with the new theory of overruling that survived, more or less, until Dobbs, where Justice Kavanaugh introduced an alternative theory. We think both are wrong. Nikki.
This might be a silly question, but in somewhere like Europe, where you have all these countries that have these constitutional
Do you mind speaking a little bit louder?
Sorry. In somewhere like Europe, where you have all these different countries with their own constitutional tribunals, but such small landmass overall compared to the United States, do those constitutional tribunals ever take into account what other constitutional tribunals are doing, so that there's not just really drastic differences in interpretations of constitutions from one country to the other?
Whenever a student introduces a question by saying it's going to be foolish or something, you need to be very wary. I don't know if you heard, but I think she said, this might sound fool. It isn't. It's very interesting. This has to do, of course, with the enterprise of comparative constitutionalism. I'm teaching them a class on that. So I guess that's where it's coming from. And I guess the answer depends on whether we're talking about the constitutional tribunals of countries that are part of the European system of human rights, that, as you know, has a central court in Strasbourg that offers both guidance and binding decisions to the countries on constitutional law related matters. So there, of course, the constitutional tribunals pay a lot of attention to what the others do, but not because they are the others, but because we are in one and the same boat, called, wrongly, Europe. But when it comes to the Constitutional Court of South Africa, for example, of course, then the real discussion of borrowing and comparative constitutionalism emerges. The one in the capital punishment cases in the United States, for example, where you are considering whether it is legitimate for the Supreme Court of the United States to borrow from the decision of the Supreme Court of Israel, for example. where there isn't any legal reason to do that? Are you still allowed to do it? How? That's what my class is about. I've been investigating, and I think you're not allowed to take it. Just kidding. But there is someone doing it here, right? It's on my competitor.
Yeah.
I'm curious how you landed on this topic and whether your thesis and just ideas that you had with Mr. Chenevert were something that you've been toying around with before Dobbs, and like Dobbs just like confirmed you wanted to write about this. Was Dobbs the impetus?
I'd say Dobbs completely unrelated to the idea. I've been thinking about this and writing about this for 25 years, more or less. My last articles on this were in the domain of juries and the requisite of a unanimous jury for a conviction. That led to an article with another student who now lives in New Orleans, Christopher Handy, and that one is on the same discussion of overruling in the Ramos case of the Supreme Court. So very unrelated to abortion, really. And then in Argentina, the main field on which I wrote apropos of this problem is drugs. In Argentina, we had 4 different case laws with 3 overrulings on the problem of whether there is a constitutional right to have drugs, so that any law that makes it a crime is contrary to that right and therefore unconstitutional. Supreme Court said A, then minus A, then A again, then minus A again. So my comment when I was a student was on that. Even my case note was on that. So I go a long way. Then my only article with the Loyola Law Review, which preceded my articles with the Louisiana Law Review and one that the Tulane Law Review has already published, that I also wrote with Chris Handy. The first one, the 2011 one in the Loyola Law Review, is part of it is on the changes of case law in Argentina. And the topic, you see, is unrelated. In fact, I think the topic of abortion is probably by miles the worst of them all. I only used it to try to catch your attention today. But it's terrible because even if you think, as I do, that people can speak the truth and that people can genuinely get it wrong about something, and that people maybe as a result of a dialogue can change their minds, even if you think that, you will for sure think as well that our passions are so strong about some matters like that one, that what is possible in theory becomes very difficult in practice. So whenever I can, I move from this domain.
You mentioned that you published both in Spanish and in English, and I'm assuming that's also abroad and here. And I'm wondering if you could speak a little bit about like the differences in publishing in the U.S. with student-run journals versus what I believe most like publishing abroad is not through student-run journals, but I wonder if you could speak to that.
We were talking about it with Katya. I'm so glad you asked me that. Basically, the joke would be everywhere, except for in the United States, we hate your system. Everywhere we think, how can there be a system where a child is checking me? I'm 70 years old. You are not child and I'm not 70. So the prevailing system, the world minus the US, up to a point, because in the US this is changing as we speak, is called peer review and exclusive submission. So the part of the student editing, my friends, there is the least objectionable part for the Europeans and the rest of the world. What we find more confusing and more shocking is the simultaneous submission system, Scholastica, Espresso, before blah blah. That's unthinkable for a South American, for a European, for an African, unthinkable for a Chinese. What you do is something virtually impossible today with the smartphones. What you do is you are patient. You submit and you wait until one day they tell you no. And then you start again and wait. And no until someone says yes. Now the no's there, they always come with a long letter that helps you improve your piece for your next attempt. So we find shocking when you get the letter I got the first time I submitted an article through the Grill in 2004, the one you've concocted so many times, that says something like, "Dear Professor Legarre, thank you for submitting your article to the Tulane Law Review. We receive 1,000 submissions every year, and you know the rest." My first one I remember was from the Stanford Law Review, who boasted back then that they received 5,234 submissions every year. Now they're probably in around 10,000. So we don't understand that they will make you an offer without giving you reasons. That we also don't understand. We don't understand that they will say no without giving you reasons. Because I am with one leg in each of the two systems, I'm not an objector. I do what I need to do when I'm with one leg, and I do what I need to do with the other leg. I can see many advantages to the simultaneous submission system. I can see many advantages to having the likes of Melanie, and remind me of your name? Charlotte. Charlotte working with me. I've seen this already, and I've seen it working beautifully. So in itself, not a problem. Well, I guess on this note, perhaps it's a good time before people start throwing things. Thank you so much.